If we go through the clauses 2, 3, 4, 5 and 6 of Article 19, we can list down all the objects mentioned therein. In general, these 9 objects may be the reasons for restrictions on the respective rights. Any restrictions should be judged on their own merit and should pass the tests of reasonableness. Now these tests of reasonableness are essentially to check the objective of the restriction. Is it mentioned in the respective clause for the right? The nature, extent and urgency of the evil that is being addressed by this restriction. The proportionality of the restriction to the evil. For example, just because someone can misuse the internet, you cannot justify a complete ban on the internet. Such a ban will fail in the test of proportionality. And the duration of the restriction. Now, restrictions ideally cannot be endless. So, there has to be some end date based on the specific situation. Till when is the restriction valid? And the conditions prevailing when the restriction was imposed. For example, if a restriction on the internet was imposed during a particular situation, it means that when the situation changes, the circumstances have improved, then the restriction ideally should be lifted. And public good versus people specifically affected by the restriction. For example, when the compulsory helmet rule was challenged. In that case, the court held that this compulsory helmet rule was reasonable in the interest of the general public, and the inconvenience caused to a smaller number of people was outweighed by the safety of a larger number of people. And restrictions can be for regulating a trade, business or profession. For example, the mandatory qualifications required for doctors or lawyers are in the interest of the general public. And restrictions can be for regulating resources or industries of national importance, such as uranium mining or gold mining or electricity distribution.